Lawyers, what's the strangest case you've ever had where you didn't know how to defend a client? Story 1. The ghost. Okay, so, in the first place, it's always nice to get a client from a business card you left at a diner. It means people pick those things up. However, when leaving business cards at diners in certain areas of town, I should expect some issues. This call came through on a dreary December day as I was sipping coffee and watching the snow fall. The caller ID read that it was the local hospital, and as I picked up, I spoke to a rather frantic young man who informed me he was being held against his will and he needed an attorney to help him. When I asked where he was, he simply said, "The 5th floor." While this may sound innocuous, every hospital has a 5th floor where Napoleon roams the halls freely and the residents speak to their imaginary friends who may or may not have been an influencing factor in why they decided that clothing was a way for the government to track them, and therefore the only solution was to create poop pants to throw off the monitoring ability of the Central Intelligence Agency. Long story short on this portion, within an hour of the call, a friend had dropped off my fee, and I was en route to the 5th floor to meet with my new client. I assumed it would be an involuntary committal defense, and after speaking with my client, I gauged that, while the man was most definitely in need of mental care, he was not a danger to himself or others, and was unlikely to be one. He had, in my opinion, been forced to agree to being committed by his probation officer, and frankly, I wasn't going to let that stand. I got the name of some contacts from his treatment plan, who were willing to vouch that he had, until recently, been compliant with his medications, and contacted his social worker, who was able to confirm that yes, since he had ceased taking the medication due to an inability to afford the medications, the county would assist him with it. A slam dunk. I would simply brandish my legal authority around the mental ward and get him released, then appear in the court to defend against the involuntary committal. Within 24 hours of being committed, my client was back at home. A hearing was set a couple weeks in the future, and I did daily checks to be certain he was compliant with his medication leading up to the hearing. Until the one day I didn't. A call from the local police was my tip-off. An older officer, one I was familiar with, called to advise they had responded to a disturbance at my client's home. He apparently had been screaming in an empty room loud enough that the neighbors were concerned and called the police. The police officer, a friendly sort, gauged the situation and decided my client wasn't a threat, but asked what the situation was. "The ghost," my client had responded. "The ghost won't get out, and it won't leave me alone." "Well," said the officer, "I can tell it to leave." So he did. He told the ghost to leave. And then, apparently for laughs, told him that it was a civil matter if the ghost refused to leave, and therefore an attorney would need to be contacted, at which point my client dropped my name, which resulted in the cop giving me a heads up. So I call my client, Dot, who is inconsolable at the concept of sharing his home with the ghost. Keep in mind, I've been to this guy's house. This is the first I've heard of a ghost, but there is a competency hearing on the horizon, and this will not play well in front of the judge. The cop said it's a civil matter. My client repeated about the 18th time after I told him I was not, in fact, a priest, but was a lawyer and didn't know how to perform an exorcism. "What do you want me to do?" I snapped a bit. "Evict it." There are moments in time when you should keep your mouth shut. This is one of them, because the immediate response was, "Can you? That'd be great." Well, that's unfortunate. So long story short, I ended up driving out there with a mock-up notice to quit, addressed to any spirits in possession of the property, located at client's address, without any authority under color of law, advising them that their possession was unlawful and requiring them to vacate within 10 days. I tacked it to his door. He was thrilled. I was thrilled that he was thrilled. The hearing went off without a hitch, and he was not involuntarily committed. I never heard from him again, but if I ever see a ghost, I know what to do. Story 2. This all started in the winter of 1999. We were still finding out details about the Columbine shooting, and all of the schools were still pretty on edge. I probably wouldn't have even gotten assigned this case if it wasn't for the hype that surrounded it at the time. What happened is definitely one of the most bizarre cases I've ever had. Really, I felt bad for the kid. He didn't want to be a part of any of this. He was perfectly fine on his own, but a few kids just wouldn't leave him alone, and he snapped. It wasn't his fault. Now that I have that part clear, I'll tell the story. Early November, I was contacted by the family of a 16-year-old boy. They needed help because their son was caught bringing a gun to school. He stole his father's hunting rifle and tried to bring it in with him in a duffel bag. I immediately knew how bad this was, before I even heard all the details. I can't say his name. In fact, I shouldn't even be talking about this, but whatever. So we'll call him Eric. I had to defend a potential school shooter. Eric was a shy kid. I could tell the first time I met him. In the visiting room at the detention center, I sat with him and his parents at a table. He wouldn't look at me, and he mostly only gave one-word answers. Eventually he started talking to me in full sentences, and sometimes he'd even go off into long monologues, but it took a lot of visits. He was very intelligent, I'll tell you that. This is what got him into trouble at school. For years, Eric got picked on at school. He told me it started in middle school when they would exclude him from get-togethers, and his friends started leaving him. Some of those friends began bullying him, for reasons he still wasn't quite sure of. They called him names and made fun of him, but he said high school was when they began to get physical. I don't remember all of the things his peers did to him, but it was an extensive list. The one remember the most was the incident that led up to the attempted shooting. He was walking out of school at the end of the day when some kids came up and started taunting him. He tried ignoring them, but they started to push him. At that point he tried to run away, but they caught up to him and started beating him. Eventually they got bored and left him, but not before taking his wallet and smashing the things in his bag. Days went by, and the kids thought they got off scot-free because Eric hadn't told anyone what happened. Technically, they did get away with it, because they were never charged or even suspended. All the blame went on Eric for what he did. One Monday in late October, he stole his dad's hunting rifle and stuffed it into a duffel bag, then left for school. He got through the door and tried to put the bag in his locker, but it didn't fit. He wanted to wait until lunch when they were all together. It didn't fit, so he brought it to class. This was his big mistake. This teacher immediately knew something was up when he walked in, and he called the principal before class started. The principal contacted the new security guard, who came in and searched his bag. That was the end of Eric's life outside of locked buildings. During my visits, I quickly was able to tell this wasn't his fault. Sure, he made some bad decisions, but he was driven to it by those kids. That didn't stop the court from railroading him. It was just a bad time, being right after Columbine. He got what's called juvenile life, which means he was locked up until he turned 21. Years have passed since this happened. I switched law firms. He grew up. Time passes quickly. It wasn't until around 2006 that I heard from him again. He called me out of the blue one day. His voice was so different I didn't believe it was him, until he started telling me details about things he told me in private when I was defending him. We agreed to meet up for lunch, and we just talked. He was out of lockup, had a part-time job, and was going to the community college. I was really proud of him. Story 3. I am a criminal defense lawyer. Client arrested on driving under the influence. Client lived in small town. He and his wife would drive to the one bar in town, drink, then walk to their houseboat after a night at the bar, 1/4 mile away. He and wife know everyone in the bar. Another patron they know gets blasted. Bar owner says she can't stay. Client and wife walk her to his car to stay there until ride comes. Client gets her in back seat of the SUV. Client is drunk, drops keys on the way to front seat, opens now unlocked front door, turns on car lights to see. He walked around the front from rear passenger. Cops are waiting to see if people leave bar drunk. Sees lights. Says he saw driving. Immediately rolled up, arrests client. Client has prior DUI from 12-ish years before. Judge agreed that it wouldn't come in, jury wouldn't hear it unless he opened the door. Can't win the case unless dude testifies. I prep him, continue to prep him, keep prepping him, but tell him under no circumstances can he say he would never drive drunk, never do anything like that. Basically, anything about the past equals no. Direct is going well, gave him a beautiful, easy last question, where he could explain the night, explain why he was upset he got arrested, because he wasn't driving and was doing everything right. I would never do something like that. Door open, judge lets district attorney in rebuttal bring in old do-I. Jury took about 25 minutes to convict, and that's about one of 100 stories. Life is never dull in the criminal defense world. Story 4. Not crazy, in a clients/lawyers behaving badly kind of way, but in a wathou kind of way. I worked on a case a few years ago representing a woman who was diagnosed with terminal cancer. She had 5 or 6 weeks at most when my firm caught the case. And we were handling the estate plan and would do the estate administration. We don't do family law. Well, she decided that after 60 years, she had no intention of dying married to her husband. So she initiates divorce proceedings and gets a decree of divorce in expedited proceedings. She's happy, she dies. Here's the rub, a quirk of our jurisdiction, and maybe this is also the law in other states, but a decree of divorce does not become a final judgment until the final judgment disposing of property between the almost former spouses. So when our client died, her almost ex-husband made a claim against her estate, asserting his spousehood at the time of her death. This lit a firestorm of estate litigation because they both had children from prior marriages. So we set to work representing her estate. We have a unified court system, but it is not unusual for individual judges to defer rulings to their colleagues in other departments. Thus, the probate judge was put in a weird position because the divorce case was still open, but in our state, death of a litigant in a divorce does not automatically terminate the divorce proceedings. So we now had dueling suits, an estate administration in front of the probate judge, and a divorce in front of the family law judge. Ex-husband kept trying to get the divorce petition dismissed because, again, under our law the judgment was not final because there had been no final judgment of property disposition. We fought against it, obviously. This litigation went on so long that eventually, ex-husband died. At this point, one might think that would be the end of the matter. However, it was not. Heirs of husband asserted in the probate case they were married at the time of our client's death. We, of course, asserted that the decree of divorce was a final judgment, subject to comity by the probate court. The probate court ultimately stayed the probate proceedings until the family law court ruled on the matter. Effectively, then, we ended up in a divorce case, not between two spouses, but between two spouses' estates. Not only that, we were fighting to keep our dead spouse divorced. Ultimately, we prevailed. But everybody agreed that it was procedurally the weirdest divorce case ever seen in the district. It's the one and only time I've ever done a divorce case. Story 5. A company had a commuter van for its employees. The driver kept it at home and drove around and picked people up to go to work, then dropped them off after work. One day on the way to work, some guy tapped the rear end of the van when it was stopped at the light, just a light rear-ender with his car. He and the driver of the van got out, no damage. They shrugged and went their ways without exchanging information. Later, a passenger in the van sued for injuries suffered in the collision. Her lawyers sued the driver, the company that owned the van, and every passenger on the van. They subpoenaed all the passengers for discovery, asked them who their personal car insurance was from, and notified those insurance companies. One of the passengers said, "I don't have a car, but my sister does." So the lawyers sued her sister. The sister said, "I don't own the car, and the leasing company provides the insurance." The leasing company was my client, and sure enough, the leasing company of the sister of a passenger in a van that was rear-ended gets sued. Story 6. Relatively new lawyer here. Had a juvenile client come in with his mom for an initial meeting/fact-gathering session. Asked the mom to wait outside while we talked to him, and she was fine with that. Kid seemed nice enough. Talked to him about his situation for a little over an hour, and that was that. Over the course of representing him, approximately 3/4 of a month, nothing out of the ordinary happened, but right after the case concluded, I found out some strange things about his mom, or who I thought his mom was. Turns out it wasn't his mom at all, but his dad's fiancée/girlfriend or something like that. She introduced herself to everyone as his mom, and had even taken my client's last name and everything. Found out later that his family had tried to just completely act like his real mom didn't exist. Like I said, nothing too terribly crazy, but definitely strange nonetheless. Story 7. I had a criminal sexual conduct case in Minnesota where my client was a legal adult when he was charged, but he was a juvenile at the time of the offense. It became a very bizarre case. Our laws allow for an adult to be prosecuted in adult court, even if they were a juvenile at the time of the offense. But, get this, if they are convicted, they are subject to penalties no more severe than what they would have received if they were prosecuted as a juvenile at the time. But that's all kind of a red herring in this case, as far as I can see. Savage is being sued, not criminally prosecuted. With a lawsuit, I have no idea whether a minor can be a defendant in these proceedings, or whether the actions of an adult who was then a minor are subject to this law. Story 8. I had a case where a client referred another client my way for representation on his charges. This is all quite some time ago and largely contained in police reports and courtroom testimony, so there's nothing privileged here. He comes to my office, we sit down and exchange pleasantries, and he starts to spin out his yarn. He starts by saying, "I don't know if you know this, but you're kind of a big deal," I say with a bit of a wink and a nod. "Exactly," he says, dead serious. "I die a little on the inside." He goes on to tell me that he and his wife were preparing to go on a vacation down to Vegas, but before heading to the airport, they decided that they needed to wash their dog and eat some unusual mushrooms. Apparently, the dog escaped from the shower and broke their glass shower door, which left a huge bleeding gash on my client's arm. Seeing that they were to be late to the airport, they threw everything they needed into a suitcase, took some substances, and headed off. At the airport, Transportation Security Administration notices my client acting suspiciously in the security line, in that he is bleeding from an open wound and gnashing his jaw. They take him aside and search his luggage. Inside, they find a large amount of loose cash and a pile of blood-covered clothes, as well as an apothecary bag with various legal supplements. In the little security detention area, my client decides that he's hot, and he takes his pants off. For some reason, this also necessitates him to stand on the bench where he should be sitting. This is how the real police found him on the handoff from TSA. So we're back in my office now. This guy is buttoned up, you know? White collar, long black high-quality trench. Sober disposition, besides the incredibly obvious narcissism. "I want to take this to the mat," he exclaimed, fueled by righteous indignation. "I need you to beat this for me." You see, the problem with narcissism, true unmedicated narcissism, is that it is impossible for the narcissist to be wrong. It is incredibly difficult to represent someone like this. Eventually, I got him a sweetheart of a plea deal that I had to twist his arm into taking. Quantities were for personal use, etc. Do some treatment. Everything goes away. There is one standout moment from a conversation he decided to have with the judge during one court appearance. "Are you employed, sir?" asked the judge. To which my client replied, "Yes, I'm an off-paper partner in a restaurant." whatever that means. Sure doesn't sound like you're doing anything illegal there. Story 9. A long time also I used to do some relationship property work. Who gets what stuff after a couple splits up? In one case I represented the woman. Her ex-partner was self-represented, and he was totally crazy. He used to write long letters to my firm, addressed to the managing partner, who was a commercial lawyer, not a litigator, so he had nothing to do with the case. The letters always explained at some length that he was physically perfect, over 6 feet tall, and a genius WTH, an IQ of 150, and that he would unleash the dogs of war and crush us all if we opposed him. Speaking of dogs, one of the main aspects of his case is that he said that after he and my client split up, he bought a dog. Then the dog died in a car crash because he was so sad after the breakup that he crashed his car, so now my client owed him money for the 3 years' worth of dog food he'd supposedly bought. He used to ring me up and scream at me over the phone. He'd get naked and throw rocks at his neighbor's property. My client was terrified of him, and even I used to peer out of the elevator before leaving work at night, in case he was waiting for me. The file was closed after he got drunk and choked to death on his own vomit at a party. Edit. I should add that while naked and throwing rocks at the neighboring property, he was also indecently exposed, which the rock throwing was intended to draw attention to. Story 10. Ridiculous, not for me, but for the accused. Here's the story. I was coming back from a wedding and booked myself an Uber share. The cab arrived and there was a couple, both clearly intoxicated. As soon as I sat, they told me that the Uber driver was difficult. He'd taken forever to drop them to their destination. I asked the driver. He said he had to drop a previous passenger en route, and considering the traffic, the time taken was not unusual. Soon the driver took the cab to their destination. The couple refused to get down and started abusing the driver that it wasn't where they lived. The driver showed me the app, that this is what they had entered as location, and he's following that. 30 minutes of further driving into nowhere, the couple had no idea where they lived, so they started abusing the driver again. Then, after 45 minutes, the driver asked them to alight and pay him his dues, since they themselves couldn't find where they had to go. The abuses got worse, and then they threatened the driver that they will anyway not pay him since he had not dropped them where they lived. I lost it at this point. The driver was a simple, poor man. I told him to lock the car and drive to a nearby police station. They told the police that the Uber driver was harassing them, and that police shouldn't come in between the company, Uber, and them. Now I told the police I was a lawyer, and a lawyer for the Uber driver now. I explained what had happened, and told him to register a police complaint. I said I was ready to depose the same before a local magistrate, and will see to it that the poor man gets his dues. Shocked the couple. I told the police to check their sobriety. This made the couple very shocked. The police made them sit in the police van and told they'll be produced before the court the next day on various charges. Eventually, on insistence of the driver, I let them go. They apologized to the driver and me, paid his dues plus a healthy tip, and were allowed to go with a stern warning. Edit. Grammar edit 2. The driver then dropped me to my place and refused to take money, saying that I had come as a god in his life. Little too much for me, I paid him nonetheless. He asked me what he could do to repay my debt. I told him, educate your children well, and henceforth, take the money from your passengers first. He, being an old man that he was, gave me his blessings. Story 11. I had a guy charged with forgery. Original plea rec was for him to serve 3 years with 12 on probation. I get the serve time down to 90 days, in a county that has a policy that for every day you spend in jail, you get credit for 2. So the guy would only have to spend 45 days in jail total. Day before we go to plea, my client calls me and says that his gallbladder or some issue had erupted, and he's going to need emergency surgery. I tell him to send me a doctor's note as soon as possible. He does. It had a doctor's office letterhead, a signature I couldn't read, So it had to be a real doctor, right? Wrong. Foolish person forged a doctor's note to get out of court for his forgery case. Needless to say, he no longer was going to only have to serve 45 days. That killed me. I had worked so hard to get that plea deal. That also taught me to never trust a client again. Well, trust, but verify. Story 12. Client was a nurse who had administered a fatal injection. Killed a baby. It was a long story. TLDR. I got her off any charges of negligence. Many years ago, but this case will stay with me forever. After hours, small rural hospital, understaffed and under-equipped. Pediatric ward, baby very ill, with gastroenteritis and hadn't responded to weeks of treatment, was losing weight despite everything. There was no doctor on the pediatric ward that night, or, in fact, in the entire hospital, when the lab phoned the baby's blood work results in to the nurse on duty and said the baby was going to die soon if he didn't receive urgent treatment. Nurse phoned the doctor on telephonic call, who wasn't supposed to go in, having already worked long hours that day, just be available for phone calls, and the doc gave instructions for a sister to give an ampoule of potassium chloride. She wrote down the instruction. The doc didn't specify that it be given orally, which was what was meant, but because the doc specified that a sister must give it, she assumed it should be an injection, as she herself wasn't qualified to give injections, but a nursing sister is. The nurse called the sister from the maternity ward to carry out the instruction, explained the urgency. The sister was very busy in the maternity ward, but came to the pediatric ward and gave the injection. Baby passed away from immediate cardiac arrest. The partners in the firm didn't want to touch the case as they thought it was impossible. But in our law, negligence has a specific definition. I won the case for the nursing sister by arguing that my client was trying her best, with only the instructions and resources at hand, under circumstances where she had been told the patient would die very soon if the treatment wasn't given. She was an amazingly dedicated person, and what happened had completely devastated her. She wanted to quit nursing. I hope she changed her mind after that. Afterward, the one good thing that came out of this tragic event was that I mentioned to a local Rotary Club member that the hospital in question desperately needed some telemedicine equipment, knowing that the club had such a project, and shortly after that, they were able to make a donation of equipment to the hospital. I even coincidentally saw that doctor in passing years afterwards, and the doctor was so grateful for that equipment. Edited to add, this was not in the United States of America. Story 13. I've defended murders and rapes and pretty much the entire gamut of the criminal justice system, except for white-collar stuff, because I'm a public defender. Far and away the hardest cases to defend are the cases where the fight is meaningful. If I believe my client is innocent, something as simple as a domestic assault could be hard to defend, knowing my client would lose their career or their college enrollment as a result. The more serious the charge, the more difficult it is. I've had clients looking at 30 years or more that I believed were innocent. Some of them went to prison for less time just to avoid the risk, and those cases eat me up because they were innocent, and I couldn't get the system to work the way it is supposed to work. The wins are worth all the pain, though. I had a kid roll the dice on a rape trial, and we got a full acquittal. He had been in jail for months and got to walk out of the courthouse with me. That feeling is unforgettable. Story 14. This is my mom's story, but I'm an aspiring lawyer, so I know this story very well. She was very good at her job and never lost a case. But one day she was called to defend a very suspicious guy that was almost certainly going to jail. He kept on refusing a lawyer, but also refused to speak without one. If they asked him a question, he would either ignore them or, and I quote, say, "No comment." It really annoyed my mother, and she almost always stayed calm. He was accused of kidnapping a 16-year-old girl and committing sexual assault on 5 others. He would not cooperate. He was definitely going to jail, but my mother's job was to reduce his time. She really didn't want to defend him, but she had to. Eventually, she managed to make a decent case and reduced his time. He initially was going to have 6 life sentences with no chance of parole, but it was reduced quite a bit. I'm not sure how much exactly, but it was enough to satisfy him. So that was my mother's worst experience because of the gruesome details and the fact that he was so calm throughout. Story 15. Not the lawyer on the other side of the lawsuit for this person. Obviously, I'm trying not to reveal details, sorry, but it's still going on. So far, we, the judge, his lawyer, I want to say it's been 9 different lawyers now, etc., have had to explain to him. Statute of limitations. Lawyers quit if you don't pay them. My lawyer cannot advise him. He has to pay the court fees. If you fire your lawyer when suing as a corporation, you will be kicked out. That during discovery, he handed over emails that had the actual date of a meeting, instead of the month earlier he was claiming. Yes, the judge can go off the record and berate you for 15 minutes if she thinks it helps the case. My lawyer will laugh in his face for asking for advice about the judge. His lawyer needs his actual address, not just a FedEx store where he picks up his mail periodically. The court isn't going to bother calling each of 8 different cell numbers that just might be the one you currently have active. The reading of the settlement and agreeing to it on record in court is binding. Simply saying that a person is the attorney doesn't actually make them the attorney. There is actual paperwork. The ruling was against him, and he can't sell what was never his. The judge can and will hold you in contempt. And finally, lawyers quit if you don't pay them. The thing is, he seems to be learning. He has paid the last 2 lawyers, and he's learning the rules. He keeps finding new things to sue over. We are now up to 11 different lawyers. Edit. Yes, we have asked for the case to be declared frivolous. The judge has denied, basically saying that he is learning and that it might not be frivolous. Edit 2. Now up to 12 lawyers. Edit 3, 13 lawyers. Edit 4, 14 lawyers. Edit 5, 15 lawyers. Edit 6, 16 lawyers, and a new lawsuit on the side. Edit 7, 17 lawyers. Edit 8, 18 lawyers. Edit 9, 19 lawyers. Edit 10, 20 lawyers. Edit 11, 21 lawyers. And he's now suing the judge. Story 16. Hey there. Thanks for commenting. Yes, I'm in private practice, although I do take legal aid certificates under some circumstances. Technically, I'm an associate at my firm, although there's only the 2 of us, so while my boss can assign me a case, I generally have discretion over the cases I take. That said, as long as you can afford my retainer and fees, which aren't high by any means, I charge my private clients essentially what I'd be getting paid if it was a legal aid case. As I believe in affordable access to justice for all, I'll usually take the case. The only types of cases that I wouldn't take would be murder, and those sort of major, very involved cases. They take up a tremendous amount of time, and I like to be able to devote as much time as is necessary to all of my cases. To be honest, I really haven't had a lot of strange cases. They're all sort of run-of-the-mill criminal stuff. I guess if I had to pick, it would be the case where a male threw an object at his girlfriend during an argument. His reason? It was the only thing within reach, and I was very angry. Yes, I've been threatened on a few occasions. In fact, I was assaulted in open court once. Maybe that's my strangest case. When the accused was found guilty, he was in the prisoner's dock and had a pen and notebook to take notes during the trial. Upon being convicted, he told me I was the worst lawyer in town and whipped his notebook at me and threw the pen at the judge, nearly striking him in the eye. Needless to say, the judge had him arrested on the spot. He was out on bail and charged him with assault on me and the judge. I ended up having to take him to small claims court for the $4,500 he owed me in fees. He defaulted, never filed a dispute note, and I got my judgment. He didn't pay, so I ended up having it enforced by way of garnishing his pay. Thanks for the questions. Cheers. Story 17. I had a client who was accused of attacking her boyfriend with a kitchen knife. She claimed it was related to unusual behavior. I asked, "Did you negotiate this in advance?" "No." "Did you get verbal consent in advance?" "No." "Were you in a context where consent might have been inferred?" "No." This was not an effective defense. I had another domestic violence case with a similar claim, but in that instance it involved a consensual misunderstanding. Witnesses explained the circumstances to the court, and the case was ultimately dismissed. After everyone had left the room except the attorneys, our elderly judge said, "I'm glad I'm going to be retired when people like this are running things." Story 18. Back when I was fairly new, I had a young man who insisted on taking a felony plea instead of the misdemeanor with active jail time. With work release, it took me ages to convince the prosecutor to offer. The young man had no prior criminal history, and no matter what I told him, he insisted he couldn't lose this new job he got. I told him there's no way to expunge a felony in Virginia. He is stuck with this for life. This is the worst decision he can ever make. I went over the consequences of being a felon so many times. I had my boss lecture him too. But ultimately, it's his life to mess up. He called me 6 months later, having lost the job and finding it difficult to find a new one, wondering if there was anything he could do to fix it. I said no, and to his credit, he acknowledged that I did tell him that. On the plus side, his story has stopped every subsequent client from making the same mistake. Story 19. Client and her boyfriend are picked up for felony shoplifting. The state has enough to prosecute the boyfriend. He's caught red-handed, but doesn't have enough on my client to charge her. They suspected she might have helped conceal some items, but he passed all points of sale by himself, and she kept her mouth shut. Her boyfriend didn't implicate her when he talked. My client has never been arrested in her life. Meanwhile, her boyfriend is a multi-time convicted felon who receives 36 months in prison, which is impressive for such a minor charge. He convinces her to come forward and make a statement, claiming that she knew all about the theft and that it was her plan, and that the boyfriend had no idea any of this was going to happen. I tell her this is a terrible idea, but she insists. We go to the prosecutor and tell him this, and he asks for a sworn recorded statement. I tell her not to do it, but she insists. We sit down at the prosecutor's office, and he tells her point blank that they have her boyfriend red-handed. Nothing she says will change that. They're not going to drop his charges, and that they currently don't have enough direct evidence to charge her, but if she makes a statement admitting involvement, they will charge her too. She still insists on making the statement. The prosecutor charges her. She does qualify for a pretrial diversion program. The prosecutor was pretty nice about it, considering she was trying to ruin his case. She testifies at trial for her boyfriend, consistent with her statement. The prosecutor on cross-examination focuses on the way she tried to claim the boyfriend had no knowledge, and in one of the very few Perry Mason moments I've seen in real life, catches her in the lie. She freezes, looks at the prosecutor. "What do you mean?" He points out that if what she's saying is accurate, then how did this other thing happen? "Oh, I see what you mean. I don't know." She then just hangs her head in shame. No further. Story 20. I had a guy declared judicially dead. The case itself was pretty straightforward. The guy had gone out drinking and fishing one night, where he and his buddies would get blackout drunk and sit on a very high bridge over a very large river. He was never seen again after that night. All the witnesses had blacked out, and he probably just fell in the river and died. 25 or 30 years later, after his wife hustled as a single mom with 5 children, one of her kids contacted legal aid because her health was deteriorating, and they wanted access to the father's pension and Social Security for her. I caught the case from legal aid, and I was actually remarkably well prepared for it, because I had done a research paper in law school on judicial declarations of death after 9/11, when a seldom used law suddenly became very urgent and needed much shorter timescales than are typically given in the statute. I was doing it in downstate Illinois, in a county they had not had a case in that since the 1800s, and it's not a thing that comes up a whole lot generally, excluding 9/11, so the judge demanded I do a lot of briefing and collect a lot of affidavits, because he didn't have a whole lot of precedent to rely on and was very nervous about the whole thing. But we got our judicial declaration of death, forwarded it on to the coroner, got the death certificate, and the widow was able to collect the pension and Social Security and get much better health care. It was not a particularly crazy case. In fact, a drunk guy drowning and never being found is an incredibly mundane set of facts. But it always impresses other lawyers, and they always have a million questions about it, because it's a pretty rare thing to do. This video does not promote illegal activity. Stories are shared for commentary and education.